Question: how hard is it to modify a custody judgment in Illinois divorce? I'm concerned my ex could come back after me and modify the custody judgment. Hi, Raiford Palmer, managing partner of STG Divorce Law in Chicago and the suburbs, answering your divorce questions. This one from a member of our private Illinois Divorce Support Network, our Facebook group, link in bio or description. The answer to that is under 750 ILCS 5/610.5. I'll put a note here in the screen or in the description. That's modification of custody judgments, or what we call allocation of parental responsibility and allocation of parenting time judgments. The short story is to allocate or to modify custody judgments, you have to wait 2 years after the initial judgment is entered to modify. You have to show a substantial change in circumstances, and then you have to show that it's in the best interest of the child to make a modification. Now, visitation can be modified without that time limit, so sooner than 2 years, as long as you can show it's in the best interest of the child. There's a couple of caveats. A court can modify a parenting plan or allocation judgment without a showing of changed circumstances, and I'm looking at the law here, if one, the modification is in the child's best interest, of course, and two, any of the following are proven. One, the modification reflects the actual arrangement under which the child is living. So for a period of time you've been living this way, you're basically adjusting the written document to show what's really going on. And then that's 6 months before the filing, that there's been no objection by the other parent, and that's gone on for at least 6 months. Provided the arrangement isn't the result of acquiescence of a parent resulting from circumstances that prevented them from giving consent. Let's say they were sick and in the hospital for months, and the other parent just took them, so they're really not consenting to it. It's just the way it had to be. Number two, modification. This is, again, 4 reasons why you can modify without showing a substantial change. 2, it's a minor modification, so it's not whatever it isn't a big deal. 3, it's necessary to modify an agreed parenting plan or allocation judgment that the court would not have approved had the court been aware of circumstances at the time of the order or approval. So you're basically showing that you wouldn't have approved this, judge, had you known what was really going on at the time. 4, the parties agree to a modification. Don't need to show it then. So those are the ways it happens. So think 2-year limit if it's custody or decision making, no 2-year limit if it's about visitation, and you have to usually show substantial change except for those circumstances, or substantial change of circumstances except for those exceptions, and that it's all in the best interest of the child. Thanks for the question. Please check out our firm, check out links in bio. Thank you.